All right. Well, that's 9 a.m. on the top. At least it is down here in Fort Bend County. So want to welcome everybody for being with us this morning, and thank you for your time to being with us so we can share this time and learn a few more things about landowner liability protection. And for many of us, whether you've got small or large acreage of land, this is a constant that you've got to be vigilant about in today's day. And I've been a landowner myself, and growing up on a farm and ranch. We've seen a changing of the times, but still things can happen. And folks that have deer leases, or they do what we call agritourism, or they do dove leases. Anything can happen to folks, even if they pay to come onto your land and everything. You've got to just be so careful that you've got yourself protected. Chances of something happening, who knows? But it's best to be vigilant and at least have yourself protected. And I don't want to say too much more, but I do want to introduce Ms. Tiffany Dowell Lashmet, which is our associate professor and extension specialist for ag law at Texas A&M University AgriLife Extension. So, Tiffany, thanks so much for being with us today. And I'm just going to, without further ado, turn it over to you and let you take it from there. Thanks so much for being with us.
Sounds great, Philip. Thank you so much for inviting me, for putting this program together. I think, like you said, it's a really important topic for all of us involved in agriculture. And so I think it's a great idea that you kind of flagged this as an issue. I'm coming to you from Amarillo, and I said earlier, for those of you who may have joined since then, it's a brisk 36 degrees this morning. So I kind of wish I was there live in Fort Bend County today, to tell you the truth. That will get started. Like Philip said, my name is Tiffany Lashmet. I'm the Extension Ag Law Specialist for Texas A&M. I'm based in the Panhandle, but I cover the entire state. And so my job's pretty fun because I just get to do programs like this and give some different kind of educational material to ag landowners. And so I want to make sure everybody can see my screen, right, Philip?
I'm certainly hoping they can.
Okay.
I can. Yes, we can.
Perfect.
Yes, ma'am.
Good. Okay. And so when I speak, I have to give a little disclaimer. It basically just says I'm a lawyer, but I'm not your lawyer. So I'm certainly happy to give general information. I'm happy to take questions. I'm going to try and pause as we go along for your questions, and I'll ask for those at certain times. I've also built some time in at the end of the program to make sure we've got time for you guys to ask additional questions there as well. So as we go, if you've got questions during the presentation, if you want to just type them into the chat box. When I stop, I'll take a minute and look at those and try to answer those as we go along. At the end of the presentation today, hopefully about 10:15, 10:20, we'll certainly allow anyone to unmute your mic and ask a question verbally if that's something you would like to do as well. So our topic today is liability protection, and I've sort of broken this down into a 5-part presentation. And so my goal is to give you 5 steps you can take today. So very practical, like something you can take home and use, make sure that your operation is protected from a liability perspective. And so I think that, when we're talking about liability, what I would like for you essentially to build with the information today is kind of a big defense folder, right? So I want you to have in place, before anything ever happens, all of these options to use as a defense if somebody does get injured on your property. The kicker to this is really you only need one of these to work, but since we don't ever know what's going to happen, it's a good idea to have all 5 of them, and there's actually more than 5 as we get into the details, but to have all of these options in this folder where you can take this to your attorney, they can pull out whatever they think they can use, right, to try to get you dismissed out of a lawsuit if it ever came to that. So that's kind of my goal today with this 5-step presentation. So the first thing I think we should start with is liability insurance. And I think of everything we're going to talk about today, this is the most important step. It's one you cannot afford to overlook. So every landowner and every ag tenant needs to have liability insurance on all of their property, period, no exceptions. And so that means if I own, let's say I own pasture land and we've got cattle there, I need to have liability insurance. If I own pasture land and we just let people come hunt deer, I need to have liability insurance. If I'm leasing land and I'm growing crops or raising cattle or whatever on leased property, I need to have liability insurance on that leased property, right? The reason for that being important is liability insurance, excuse me, liability insurance offers you two major benefits. One of them that we're all pretty familiar with is the concept that liability insurance gives you coverage under, up to the policy limits if a covered event happens. So if someone came out on your ranch and got injured, the insurance company would be willing to pay up to your policy limits, right, to settle that claim. But the second benefit of insurance I don't want you to overlook is the fact that liability insurance also provides you a defense. So what that means is if there's a covered claim that happens on the property, right? Somebody gets injured on my property, my first phone call is to my insurance company and they're going to defend me. In fact, they're going to go out and hire me an attorney on their own dime to get me out of that lawsuit, right? And I mean, this isn't like shocking news to you. Lawyers are expensive, right? So having that kind of almost lawyer on speed dial that's not coming out of your pocket is a huge benefit of liability insurance. The next thing I'll say is, in general, liability insurance is usually really affordable. Now, you may think, hang on a minute, I saw our bill last year from the insurance company and I would not call that affordable. What you probably would have seen is your total bill that includes all of your liability coverage plus your property coverage. And if you look at the breakdown, bills usually will break it down kind of line by line. The property coverage is what's so expensive. The liability coverage generally is pretty cheap. Just by way of example, last year my husband and I bought a half a section of land here in the Panhandle. I think we have $500,000 in liability coverage, and we pay about $100 a year. Right, so $100 a year gets me $500,000 in coverage plus a lawyer on speed dial. That just seems to be money well spent to me. Okay, so I think that's really important. How much insurance you need really depends on what you're doing. I like to think about it kind of like a totem pole where there's, kind of lower levels and then it goes up to the top. And so we've got one pasture that we lease. No one hunts there. It's in the middle of nowhere. It's not on the main highway. We just have cows there. So we have liability insurance, but we have a pretty low amount. We're low on that totem pole. All right, contrast that with last fall, I took my kids to a pumpkin patch and it was lovely. All I could think about were liability issues the entire time, right? Their risk is much higher than mine. They're high on the totem pole. They open it up to people. They've got little kids running around carrying sharp objects to cut pumpkins. There's vines everywhere and bugs and whatever else. Like, they've got a lot higher risk than we do on this pasture I'm mentioning. So that to me is where it's really useful to work with an insurance agent and or an insurance company that understands agriculture. I don't care who you buy your insurance from. Just buy it somewhere. I personally do like to have either a company that's kind of an ag type company, or at least an agent, who maybe writes for like a big non-ag company, but the agent themselves understands ag. And I think that the real benefit of that is they can help you analyze the risk. It's also useful to help make sure you've got all the coverage that you need if they understand your operation. So I would kind of recommend that. The one place I will tell you, I think that I can give you a number, right? So I'm saying, how much insurance do you need? I don't know, it depends. But I will tell you, if you are gonna open your property up to a recreational user, okay, we'll talk in a little bit about what that means, but anybody that's gonna come and hunt or fish or swim or ride four-wheelers, if you're going to have those types of recreational activity, I would have at least the insurance level mentioned in the Texas Recreational Use Statute. this is a little bit of a teaser because we're going to talk about that statute at the end of the program. I'm going to tell you what that amount is. But because of that statute, if you're going to have recreational users, I would have at least that amount of insurance or higher. So that's kind of the one little ballpark I can give you as far as the amount. The next thing I would say is you want to make sure that every activity you have going on is covered by your policy. So, you know, for example, I've seen some folks who might have like a farm and ranch policy, but then they start kind of expanding the operation. And so now they have like a roadside stand where they're selling fruit. They've got a pick your own strawberry operation, or they decided they're going to start selling their beef on the internet and shipping it to places, right? As we get kind of farther away and we start diversifying our operation, we need to be really careful and make sure our insurance covers that. And again, that's where working with an agent that you can really talk through these things with who understands can be really important. And so a lot of times if you've got a policy and it doesn't cover a certain activity, all you have to do is get an endorsement to add that type of coverage to your policy. So that's something I would be aware of. Sometimes people will ask, well, you know, we don't have a ton of land. Maybe we have 10 or 20 acres and our house is there. Does our homeowner's policy cover that? Double check that. A lot of times if you've got kind of a smaller piece of land where your house is, your homeowners may cover liability for the entire property. But again, do make sure if you've got other things going on there, that's covered. One example of that, the place that we live has 10 acres in our house. And when we bought that, we got our homeowner's insurance. It covered all of the land, etc. But before we started putting animals there, right, like my kids' horses, and we've got a couple of show heifers that are there, I called the insurance company and said, hey, does my homeowner's policy cover if livestock gets out on the road? And they said, no, but you can add an endorsement for that. And it cost me like $12 a year to add that endorsement. So that's, again, one of those situations you just have to make sure all of that coverage is lined up how you need it. Everything is covered on your policy. Another thing to be aware of is watch for any caps on coverage in the fine print. As far as liability insurance goes, I'll tell you where I see that is when you are dealing with, okay, so for example, I've seen farm and ranch policies that are $1 million policies, and then they have a cap on pesticide drift damages. So if you're like applying, you know, whatever, 2,4-D or dicamba or whatever it is, and you drift and damage your neighbor, there's a cap that says we're only going to cover up to $25,000 in spray drift damage. And there's a big difference between 25,000 and $1 million, right? I've also seen some policies where they limit, they'll cover like ground application of pesticides. They won't cover aerial application. So again, watch for those types of limitations. Watch for any caps like that that are kind of in the fine print of the policy. The last thing that I want to say on liability insurance, and then I'm happy to take your questions on insurance. If you'll type those in the chat box, we'll look at those next. I want to talk about umbrella policies because I think that there's kind of a little bit of misunderstanding generally about how those work. And so there can be a real benefit to an umbrella policy. So don't hear me say that you shouldn't have one. They can be very useful. I just hate the way that they're named because I think that it gives some bad impression of what they do. So when we hear umbrella, people a lot of times think, well, an umbrella covers everything, right? So if I have $1 million umbrella policy, everything is covered. I wish they would have called it a top hat policy because here's how it actually works. To get an umbrella policy, you've got to first have a base liability policy. Okay, that base policy describes everything that's covered and not covered. Okay, when you buy the umbrella, all that does is sit on top of the base policy to increase the dollar amount of coverage. What it doesn't do is increase the scope of covered activities. Does that make sense? So it's more like a top hat where it sits on top and gives you extra dollars of coverage. It does not change the scope of what's in and what's out as far as covered or uncovered activities. Okay, so with that said, a lot of times you can get a liability policy, and that's get a base policy and then buy an umbrella, and that's a really cheap way to increase the amount of coverage that you have. But what I don't want that to do is kind of lull you into this false sense of security that, well, I don't have to worry about that because I have an umbrella policy and that covers everything. That's not the case. Okay. So that's my spiel on liability insurance. Like I say, I really think that that's the most important thing you can do to protect yourself, to protect your operation, to protect your land, is to have liability insurance. Okay. Any questions on liability insurance? I'm checking the chat box. I don't see any yet. Again, as we go, I'm going to take little pauses like this to look for questions. Feel free to type them in if you have them. And then we'll also leave time at the end. So if you want to save them until the end or you want to ask them aloud, we can do that at the end. Okay, looks like no questions to start with here. So let's go ahead and move to the second concept, which another way to defend yourself against a liability claim is to meet the standard of duty you owe to people coming on the property. Now, this is going to be a little bit law schooly, okay? So I want you to hang with me. The way the law works is it says, as a landowner or an occupier of land, so this would apply like to a tenant or as well. As a landowner or an occupier of land, you owe a certain duty to people that come on the property. In other words, you have a certain responsibility to people who are coming on the land. If you meet your required level of responsibility, you're not liable for injuries. If you fail to meet that required level of responsibility, that's when you can be liable. All right? So what level of responsibility do you owe, right? That's what we need to know. It depends on the type of person coming on your land. And so Texas law puts people essentially into three categories. The first category is called a trespasser. Now, for our purposes here, this is going to be anybody who comes on the property without permission. I don't care about purple paint or no trespassing signs. That doesn't matter for liability. That matters for other legal issues, okay? So if somebody comes on your land without your permission, we deem them a trespasser for liability purposes. And the only duty you owe to a trespasser is not to intentionally injure them or to act with gross negligence. Okay, this is a very landowner-friendly standard. In other words, it's really hard for an injured party to successfully prove that a landowner acted intentionally or with gross negligence. It's tough to prove that, okay? Intentional, I think we all get that. Gross negligence is a really high level of disregard. Courts say that you have to show a conscious disregard for human life, and it needs to be something that kind of shocks the conscience. Okay, so again, very hard to prove. So as a landowner, that should let you take kind of a deep breath and not worry too much about people coming on your property without permission. Okay, so I kind of like to use an example. Let's say that we've got a property and in the spring, people pull up and hop the fence to come take pictures with the bluebonnets, right? I get this call every April. And so let's say that happens, they fall in a hole and break their leg. Are you liable as the landowner for that injury? No, right? Because you didn't intentionally injure them, and you're not gonna be able to show gross negligence if you've got a hole on your private property, right? If you push them in the hole, we've got a problem. But other than that, you're not gonna be liable, all right? So trespassers is our first category of people. The second category of people is called a licensee. That's going to be somebody who comes on the property for their own benefit. So if somebody comes over for dinner, they're a licensee. Probably if you let somebody come hunt for free, they're going to be a licensee. All right. and you owe a higher duty to them. So what the law says is you have a duty, you still can't intentionally injure them or act with gross negligence, right? You can never push them in the hole. But now you've also got a duty to warn them of dangerous conditions known to the landowner that might not be visible to the plaintiff. So in other words, you need to think about your property and think about what hidden dangerous conditions are there. And in general here, we're looking for natural conditions. Let me back up. In general here, we're looking for artificial or man-made conditions. Generally, a natural condition won't fall under this duty, okay? If you can think of some of those on your property, you need to either warn people about them or make them safe. So I think the classic example is if you've got some old abandoned well that maybe isn't plugged or something, you better be warning people about that or making it safe, because that strikes me as a classic artificial, dangerous condition that would be hidden from a plaintiff, okay? So how do you do the warning? There's no magic rule. You just have to do something that's reasonable. So you could put up a sign, for example. You could, if you've got a hunting lease or some other lease where people are coming out and you're signing something, you could attach a map. That's what I like to do. Print off a map, kind of highlight, here's where you can hunt, and here's all the dangerous conditions. Right? That way it's in writing, so you've got proof that you gave that to them. Okay, so that's for a licensee. The third category of person is called an invitee, and that's going to be somebody who enters the property for mutual benefit of themselves and the landowner. So that's going to be like the plumber or the UPS man. All right, we owe the highest duty to them. And that duty is we have to warn them of dangerous conditions we know of, or that we should know of with a reasonable inspection. See how that's higher? So for a licensee, you only have to warn them of these hidden dangerous conditions you know of. For an invitee, it's the ones that you know of or that a reasonable landowner should know of with a reasonable inspection. Okay? So it's almost this duty to like reasonably inspect your property. Now, people sometimes get panicky here and they'll be like, well, what am I supposed to do? I can't go out and drive all 1,000 acres every day to look and see if, whatever, the hogs have dug new holes. It says a reasonable inspection, all right? So, when we're thinking again about especially artificial dangerous conditions, there's probably not going to be a ton new of those popping up all the time. One thing I will say, we have hunters come for deer season. It's probably worth kind of making a circle around the weekend before they show up to make sure there's not some new warning that you need to make. Okay? And I always tell people too, I think you're better to overwarn than to underwarn. So if there's something you think, well, I wonder if I need to warn them about that, just do it. It's not going to hurt to give an extra warning. Okay? One question that I almost always get here when I do presentations, I'll answer this and then I'll take your questions, okay, is what about snakes? All right, and so the general rule in Texas for any sort of wild animal, so snakes, scorpions, wasps, spiders, ants, anything like that, the general rule is a landowner is not liable for those injuries, subject to 3 kind of screwy exceptions. The first exception is if you brought the snake in from outside, you can be liable. Right? So if you got just a snake that is like native, no problem. If you go somewhere and bring a snake home and turn it out, you can be liable for that. The second exception is if you reduce the animal to your possession or control, you can be liable. So if you like go and catch all the snakes and have them in like a snake den you build or something, you can be liable for that. Keep in mind, someone had to do these things for this to be in the law, right? So I know it sounds crazy, but it happens. All right. And then the third thing is if the animal is in some sort of artificial structure, you can be liable if it was hidden and you knew or should have known and warned the plaintiff. We've seen that recently in a Supreme Court case where there was a spider that bit somebody in a hunting cabin. So you can potentially be liable there if you knew or should have known about the animal and you did not warn the plaintiff. Okay? So all of this to say, I kind of go through all of this because one solid defense to always use is, I met the standard of care that I owe. And since the highest standard of care is to warn of dangerous conditions that are hidden that you either know or should know of, I think it's a good idea to just try to do that for everybody. So if you can make those warnings of any dangerous conditions to anybody coming on your property, great, right? Because that's the highest standard of care you owe. Doing that can serve as a legal defense in the event that there's an accident. Okay, so with that, it looks like we've got a couple of questions in the chat box. Let's see. Okay, we're going to back up to insurance. What's the difference between an umbrella policy and an excess liability policy? Gordon, I'm not familiar with excess liability policy. I would just check with your insurance agent. You just need to look at the terms of that policy and see what that is. It could be the same. I just am not familiar with that specific term, and so I hate to give you bad info. Sorry about that. The second question is a good one. Can land and things on it be considered an attractive nuisance and therefore trigger the liability coverage? So attractive nuisance is a legal concept when you've got trespassing children on the property. And what it basically says is, we're gonna kind of give kids a break if they're trespassing on your property. In other words, we're not gonna hold them to that super high trespasser standard. We may give them a break, and you may be liable if they can prove attractive nuisance. And so for an attractive nuisance to occur, number one, again, it has to be an injured child. In general, it's usually a kid that's gonna be under 14. That's kind of the standard in Texas. They have to be unable to appreciate the danger of the activity. It has to be a dangerous artificial condition on the property, and you have to have reason to know that it's likely that kids are going to trespass. So, for example, we've seen like attractive nuisance cases involving swimming pools, where, like, you know, let's say that you live next to a school, you've got a swimming pool, and some young kid, you know, sneaks in and drowns. That's a situation where courts may say there was an attractive nuisance. Again, it's not going to be for every, you know, trespasser. Only kids, and they have to be young enough not to appreciate the danger of what's going on. So, for example, there was one case here in Texas where I think he was 15 or 16, but a teenage kid was climbing on like an electric pole and ended up getting shocked by the transformer. And they claimed attractive nuisance, but the landowner won, or it was the electric company, I think. They won because there was evidence that showed this kid knew it was dangerous. His friends told him not to do it. There were just multiple things there that showed he did appreciate the danger. So again, attractive nuisance does exist. That's something that could be raised by a party, again, if there's an injured child trespasser on the property. And again, I think that's a good example of why we have to have that liability insurance, right? Because in the event that they claim attractive nuisance, we can't get the case dismissed, we end up going to trial. That's where we need that insurance to cover that judgment and to provide our lawyer in that scenario. Okay, that looks like all the questions so far. So let's move to number 3 on our list, and that is obtain a written liability waiver. Sometimes you'll see these called liability release. It's the same thing. And in general, what it is, it's just a signed like document or kind of contract between the parties where the person who's going to come on the property essentially says, yes, we know that there are risks associated with coming on the property or doing this activity. We understand them, and we agree that we're not going to hold the landowner liable for negligence if we're injured. All right. So the first question I get a lot of times is that paper, you know, is that even worth the paper that it's written on? The general answer is yes. So in general, Texas courts will enforce a release if it's properly drafted and if the injured party is an adult. All right. Now, I will tell you, courts disfavor these, and if things aren't done exactly to the letter, they will not enforce them. All right, so just be aware of that. And in general, where you see liability waivers used is for people that are coming out for recreational type activities. So hunters, again, people swimming or riding four-wheelers or riding horses, that's kind of where you would see the liability waiver. You know, I don't like hand these out to people, my family coming for Christmas dinner. I wouldn't hand these out to somebody who's working for me, you know, employees or even independent contractors. That's just kind of not what they're really designed for. But for those recreational users, this can be really important. And you see here it says that the courts will enforce these if they're properly drafted and if the injured party is an adult. Let's talk about that for a minute. So the Texas Supreme Court has never answered the question of, is a liability waiver enforceable if it's signed by a parent on behalf of a minor child? The Supreme Court's not answered that. There's a lower level opinion and a couple of federal court opinions applying Texas law where they've said, no, we're not going to enforce a liability waiver if there's an injured minor. It's kind of a public policy thing. They don't want to leave an injured kid without some sort of remedy. So here's what I would tell you, because we don't know the law on that in Texas, right? Until the Supreme Court speaks, we don't know for sure. I still get the waiver. I have the parent sign it on behalf of the minor child. I put it in my folder, but I know in the back of my mind that may or may not be enforceable. Okay, so keep that in mind. On waivers, like I said, courts are really particular about these. And if everything is not done exactly to the letter, they're likely to say it's unenforceable. And so because of that, I would really use an attorney to draft a waiver. All right, there are things in the law that you can do yourself. There are forms you can go find and fill in the blank on the internet. I would not do that with a liability waiver. And again, it's just because such a strict application by courts. And so I know that nobody wants to go hire a lawyer and pay them to do a waiver. I'll give you kind of two thoughts. The first one is, if you get an attorney who does these pretty frequently, they probably have a template that they're just going to kind of tweak and make fit your scenario, but that shouldn't be crazy expensive to get done. The second thing is, the law on this doesn't change very often. And so in all likelihood, you can probably hire a lawyer and get a waiver this year and then use that for the next 5 or 10 years without any trouble. So if you kind of look at it on a per year cost, that cheapens it up a little bit, if that helps ease the heartburn about having to pay that attorney. As far as how waivers need to be drafted in Texas, there's kind of two main things. Courts say that they need to be express and conspicuous. So express means that it needs to actually say that the person is releasing or waiving all claims against the landowner, including negligence. You actually have to list out that you're releasing claims of negligence for it to work. If it just said we won't sue the landowner, for example, that's not going to fly. It also needs to be signed near the time of the injury. There's no case law on what that means that I've been able to find. And so I'll just tell you what we do is we get them once a year, right? So if we've got the same deer hunters that come every fall, we're going to get a waiver every fall. And I think that's probably good enough. The other thing that it has to be is conspicuous, which that means it needs to be not hidden in the fine print. So do not make this be page 5 of your hunting lease. It needs to be a separate piece of paper, big bold letters, waiver of liability or release of liability. You just don't want anybody to think, be able to argue, well, we didn't know what we signed. We didn't know we were waiving those claims. Okay, so that's my spiel on liability waivers. Again, none of these things are like bulletproof for every situation, but this is a good one to have in that kind of defense folder as an option to use if somebody gets injured. All right, it looks like I don't see any questions so far on liability waivers. So again, if you've got those, feel free to go ahead and type them in or ask them at the end as well. Okay, Step number 4 is you can consider the use of a business entity to limit some liability exposure as well. Here's kind of how that works. There are certain business entities you can create, and the creation of those can offer some limited liability for the owners. So in general, that's going to be things like an LLC, a corporation, a trust, to a certain extent, a limited partnership, okay? And just here's kind of how that works. So let's say that I own my ranch as Tiffany, and somebody goes out there and gets injured. If they sue me, they can go after the assets of the ranch, or they can come after my personal assets since I own it all, right? One way to kind of put an extra layer of protection in there would be for me to create Tiffany LLC. So I would create this new legal entity. I could deed the ranch to the LLC. Okay. In this scenario, I, Tiffany, do not own the ranch anymore. The LLC does. And now if somebody gets injured on the ranch, they can go after the LLC assets, but my personal assets are protected because I don't own it. Okay. So, using a business entity in that context can be really helpful. And a pro of these entities we're talking about is the liability protection. I know some folks that use multiple business entities. So there's one family that I know that has a family farm and a custom harvest business. And right, because driving combines up and down the road is dangerous, they've got a couple of LLCs. So the farm is in one, the custom harvest business is in another. And that way, if there's an accident with a combine on the highway, those assets may be at risk, but the farm is protected, the personal assets are protected. Okay? Now, before you just jump off and decide, well, we're going to create a business entity because that's a way to limit liability, that's true. And like I said, that's a pro of these entities. There may be cons as well, and you need to weigh the pros and the cons to decide if it's worth creating the entity. To do that, I really recommend I would visit with my attorney, and I would visit with a CPA or your accountant, because there can be major tax implications here. Not only is it the hassle of the additional paperwork, additional tax return, franchise taxes, those sorts of things, it may change your tax rate as well. So I would really, like I say, encourage you, visit with an accountant, visit with an attorney to decide whether the pros outweigh the cons of these entities. One other con that I want to mention has to do with if you receive farm program payments from like the FSA office, right? So that's the Farm Service Agency. So by way of example, let's say that you have ARC or PLC coverage under Title I of the Farm Bill, right? So you've got property with base acres, you're enrolled in ARC or PLC. The way that program works is there's a program payment limit of $125,000 per person actively engaged in farming. So if let's say we have a husband and a wife and they're both actively engaged in farming and they own the operation in their own name, that's two people. So they can receive up to $250,000 in program payments. If that husband and wife put that exact same operation into an LLC, now it's one LLC and the program payment limit is one, so that's $125,000. Okay. So I mentioned that because I know some farmers, like big operators here in the Panhandle, that have kind of looked at this and said, you know what, we're better off not creating the business entity, getting the extra program payments, and we can use some of that extra money to just buy a bunch of extra insurance. Okay, so again, you got to weigh the pros and cons of any entity. And then which entity you should choose, I hate to give you the lawyer answer, but it really does depend on your operation. There are pros and cons, again, to all of them. I guess in general, I usually like an LLC. They're a little less formal than a corporation. They're a little easier, I think, to understand and maintain. There may be reasons that a corporation's better. There may be reasons that you want to trust, that can serve some different purposes a lot of times, especially if you've got concerns about creditors of, potential owners or something like that. So again, it depends on your operation. That's where your lawyer should be able to help you analyze that. And the last thing I'll say on business entities is to keep in mind, you're going to have to jump through the right hoops to get the protection. So in other words, right, if I create my LLC, I actually have to operate out of that. So I've got to put the property into the LLC. I need to have a separate bank account. I need to only pay for, things for that portion of the business in the LLC. I have to file separate tax returns. If I don't jump through those hoops to actually treat it like a separate entity, there's the chance that the court might do something called piercing the corporate veil, where they kind of disregard the entity because you disregarded it. And now you potentially could be personally liable again. So just keep that in mind. All right. Any questions on business entities? It looks like I don't see any in the chat box yet. Okay, let's move to step number 5, which is actually a 3-parter. So this will take a little bit of time. But so one thing that you want to do is make sure that the limited liability statutes we have here in Texas apply to your operation. So there are 3 statutes in Texas that have been passed by the legislature that offer limited liability or additional protections to ag landowners if certain requirements are met. These are great, frankly, because what they do is kind of change the analysis in favor of the landowner if you meet their requirements. And we're going to talk through all of them one at a time, but when you look at them, getting the protection is free or super cheap. So I really would make sure, take the time to go home and kind of do your homework, make sure that these would apply, because you want to have these options in that defense folder that we talked about. Okay, the first one we're going to talk about is the recreational use statute. It's my favorite, okay? And what the recreational use statute says is that landowners or occupiers of land, so again, this could apply if you're leasing land, all right? So landowners or occupiers are liable only for intentional acts or gross negligence if the following 3 requirements apply. Now, this should ring a bell to you. Intentional acts or gross negligence. That's the trespasser standard. In other words, this statute says if the 3 requirements apply, you get to treat these people on your property like trespassers, even if you gave them permission to be there, even if they're paying you. Okay? So what it does, it changes that slide about what duty you owe, and it basically says you're only liable if they can prove that super difficult trespasser standard. Okay? There's 3 requirements in order for this to apply. The first one is you've got to have land. Now, this can apply to agricultural land and non-agricultural land. We're just going to focus on ag land today. All right, but if you've got non-ag land, you can go look up those provisions as well. All right, so number 1, you've got to have agricultural land. The statute says that's land that is suitable for growing crops, raising livestock, or forestry. Okay, suitable for. You don't have to be doing it. All right, and I do not care what the appraisal district says. All right, so I always tell people on this one, I want you to think about a goat, right? Is my land suitable for raising goats? And I don't know. I think goats can live on the moon from what I can tell, right? So it's a pretty broad standard. All right, so number 1, ag land. Number 2, the injured party had to be there for a recreational purpose. So that's going to be, there's a whole list of things. Hunting is the first one listed. That's what most people ask me about. Hunting, fishing, hiking, biking, swimming, water sports, riding 4-wheelers, like nature photography, picnicking, walking dogs. And then it says, and anything else associated with enjoying nature or the outdoors. So that's a pretty broad standard, right? The only limitation I would offer you here is there's one appellate court case in Texas that says if somebody is injured while they're attending an outdoor wedding, that is not a recreational activity. I just mentioned that because a lot of people are creating these like wedding barns now, right? The recreational use statute's probably not going to apply if it was a guest attending the wedding that got injured. Okay? So again, number 1, ag land. Number 2, the plaintiff is there for a recreational purpose. Number 3, you've got to meet one of the 3 monetary options. So if you look at this slide, there are 3 kind of gold colored bullets. You need to make sure you meet one of those. Okay? The first option is if you do not charge a fee. All right, so if I let my neighbor come hunt hogs at my ranch for free, I've met all 3 requirements, the recreational use statute applies, and I'm liable only for intentional acts or gross negligence, which is really hard for my neighbor to ever prove. Okay, so if you let him come for free, that's option number 1. Option number 2 says, if the total charges collected over the past calendar year are not more than 20 times the total amount of ad valorem taxes imposed on the premises for the previous calendar year. In English, what that says is you need to get a piece of paper and make 2 columns. In the first column, I want you to add up the total number of recreational users, the income you made from them last year. So anybody that paid you to hunt or fish or ride 4-wheelers, get a total of income from last year. In the second column, I want you to add up all of the property taxes you paid last year anywhere in Texas. Not just the place where you have the hunters, right? If you got a big house in town, count that too. Total of property tax. So long as the income is not 20 times more than the taxes, the statute applies, and you are not liable for anything besides intentional acts or gross negligence. Okay, most people fit there. You've got to make a lot of money from hunters for that not to work. Okay? And here's your third option. If you have liability insurance coverage of at least $500,000 per person, $1 million per occurrence, and $100,000 for property damage. If you carry that level of insurance or higher, the recreational use statute applies. We don't care how much you charge. It doesn't matter. And I mentioned this earlier, there's an added benefit here. If you carry that level of insurance or higher, any damages that an injured plaintiff can recover from you under this statute are capped at your insurance. Okay, that's a big deal. In other words, they can't recover a huge judgment and you owe money out of pocket. And that's why I said earlier, if you're going to have recreational users, I would make sure I had at least that amount of coverage or more because of this statute and that cap it offers. Okay, that's the whole statute. There's no exceptions. There's no signs you have to hang up. It just applies if these 3 factors are present. Okay, I would really encourage you, if you have any type of recreational users, you need to make sure that this statute applies. Okay, I don't see any questions yet on the recreational use statute. Feel free again to type those as we go. Let's look next at the Texas Agritourism Act. And there's my kids at the pumpkin patch I told you gave me anxiety. So the Agritourism Act, when this came out, I thought, well, I don't care about this. We don't have a corn maze. The way this is written, I think it's going to apply to almost all ag land in Texas if you're doing certain activities. Okay? So what the statute says is that agritourism entities are not liable if the plaintiff is there for a recreational or educational purpose and the landowner either hangs up a sign or gets a release. Okay? So what's protected here is an agritourism entity. That's defined as a person engaged in providing an educational or recreational activity on agricultural land, regardless of compensation. Okay? And a recreational activity has that same definition of the other statutes. Hunting, fishing, hiking, biking, all that. Plus, it also applies to educational activities. So that sounds to me like field days or, you know, the 4-H club or the Boy Scouts or something like that. Okay, so I think it's a little broader there, right? And so this says if you've got ag land, right, that land that's suitable for growing crops or raising livestock, the plaintiff is there for a recreational or an educational purpose, you are not liable for injuries if you hang up a sign or you get the Agritourism Act release. So let's look at those. Your first option is to hang up the sign. This has to be posted and maintained in a clearly visible location on or near the premises where the activity is conducted. So I just copied and pasted this right from the statute. You can make your own sign if you want to. There's a number of groups that sell them. So Texas Farm Bureau, Texas and Southwestern Cattle Raisers, Texas Sheep and Goat Raisers, Texas Wildlife Association, South Texans for Property Rights. They all sell them. You can get them for like $5. Okay. So what I tell folks is hang them where the activity happens. If it's, you know, if you've got hunters, I'd probably put them on all the gates because they're gonna have to come in a gate theoretically. If you've got like a swimming hole, I'd put it at the swimming hole. So that's the first option, is to sign. The second option is you can have them sign an Agritourism Act release. This has to be signed before the activity by the participant or their parent, guardian, or managing conservator. It needs to be separate from any other agreement. So again, don't put this in your hunting lease, separate sheet of paper. And you've got to print this in at least 10-point bold font. I don't know why they chose that, but that's in there. Okay, so again, I copied and pasted this language right from the statute. I would just print it off, you know, say who is being released, and then have them sign it. Okay, again, you can do either the sign or the waiver. There are things I like about both. I like the sign because I can just hang it up and kind of forget about it, right? I don't have to chase somebody down with my clipboard. The one place I like the waiver better is if you're going to have a minor child on the property. So anybody under the age of 18. And the reason is this. Remember earlier when we talked about general liability waivers and I said courts may or may not enforce those if the injured party is a minor? If you look at the language of the Agritourism Act release, it specifically says by statute, it can be signed by the participant or their parent, guardian, or managing conservator. That looks like pretty good evidence to me that the Texas legislature intended this statute to be able to waive claims of minor children. Okay, there's no cases on it, but that language I think is pretty strong. And so what I would recommend is if you're going to have kids under 18, I would get the waiver, all right, because of that issue. If you're just going to have adults, the waiver or the sign, either one I think is fine. Listen, I'm professionally trained to be paranoid, so I would probably get both. All right. The last thing on the Agritourism Act, there's a list of exceptions here when the Act's defenses don't apply. There's no case law on those. We're going to just kind of ignore them today. What I would tell you is pay $5 for the sign, let the lawyer fight about the exceptions. Okay. Questions on the Agritourism Act? It looks like we've got one. Is there specific wording we need to do if we make our own? Can we copy from another sign? Philip, for the Agritourism Act sign, you have to use this exact language. All right, it's exactly in the statute. Don't change it at all. Use the exact language from the Agritourism Act statute for that to apply. Okay? Any other Agritourism Act questions? Okay, let's move then to our last statute, which is the Texas Farm Animal Liability Act. Oh, here's one more that popped up real quick. Oh, Phillips has got it. Great. Okay, the Farm Animal Liability Act. This used to be called the Texas Equine Act, and then in about 2011 or so, they changed it from the Equine Act to the Farm Animal Liability Act. So they just broadened the category of animals that it applies to. So now it also applies, you know, to cattle and sheep and chickens and turkeys, ironically enough, applies to those as well as equine animals. Okay? And so this statute's really important if you've got any sort of livestock or horses. The summary of it, what it says is that a person is not liable for damages to a participant in a farm animal activity or livestock show if the injury results from risks inherent to the farm animal activity or livestock show, and then of course it's subject to a number of exceptions. So in other words, guys, what this is like I think 48 states have these acts. And the legislature basically says, we understand that there are inherent risks with being involved in farm animal activities, right? If you put the best rider on the best horse, there is still an inherent risk that something crazy could happen. And we're not going to hold animal owners liable in that scenario. Okay, that's the design of the statute. Okay, so it protects, again, it protects you if the injury is caused by an inherent risk. There's a big, long definition of what inherent risks are. I'll be honest with you, the first one almost looks like anything to me. It says the propensity of an animal to behave in ways that may result in injury. In my mind, if there is an injury involving a farm animal or an equine, you can fit it right there. So I think this is a potential defense in any scenario involving a farm animal or an equine. All right, we're going to look at a couple other limitations in a minute. So we're not going to go through these because I just think it's so broad. Okay, so if you're just a regular person like me, that we own some horses that my kids ride, we've got cows and sheep at the house. I don't have to do anything else. I don't have to hang up any signs. The statute just applies, and I'm not liable for any sort of inherent injury. If you are a farm animal professional, then you have to have a sign, okay? And so a farm animal professional is a person engaged for compensation in instructing a participant or renting to them an animal, equipment or tack, or who provides veterinary or farrier services. So in other words, if you're giving riding lessons, if you're letting somebody come and rent your horse or whatever, if you're a vet or if you're a horseshoer, you need to hang up the sign. You've got to post it where the activity is conducted. You also need to include this language in any contracts that you may have. And here it is. Again, I copied and pasted this right from the statutes. I know that Texas Farm Bureau, and I think that Cattle Raisers also sells these signs. You just hang them up. If you're a farm animal professional, you need to make sure you've got the sign. Okay, there's a separate sign for livestock show sponsors. So if any of y'all are on like your local stock show board or a rodeo board or horse shows or barrel races, anything like that, there's a separate sign that you need to hang up. And here's the language from that. It's similar, but it's a little bit different. And so you have to have this sign if you're a livestock show sponsor and you want to use this defense. So for example, a while back I judged a sheep show and there was a sign on the wall that said, "We're not liable for injuries," and injuries was misspelled. That doesn't work, okay? You need to have this specific sign. Okay, I do want to talk through the exceptions to the Farm Animal Liability Act because we do have some case law on these. And so just for a way of background, how this would work is if somebody gets injured with something involving a farm animal and they file a negligence lawsuit, okay, so the plaintiff would file the lawsuit. Then the animal owner is going to say, I have a defense. The Farm Animal Liability Act applies. Court, you have to dismiss the case. All right? The plaintiff then would have the chance to prove one of these exceptions. And if they can show that an exception applies, then the case goes forward. In other words, if an exception applies, the defense doesn't work. Okay? Let's look at these exceptions. The first one is if the injury was caused by faulty equipment or tack provided by the defendant who knew or should have known it was faulty. that seems fair to me. I don't think it's an inherent risk of riding a horse. You're going to give me a saddle that you know has a busted cinch, right? The second one worries me, and we're going to talk about this one in a case here in a minute. It's an exception if the defendant provided an animal to the person and did not make a reasonable and prudent effort to determine the ability of the participant to safely engage in the activity and to safely manage the animal. So what that says to me, right, is before you stick somebody on a horse, you better ask some questions, right? You better figure out how much they've ridden before, and you better remember that everybody thinks they're a better cowboy than they actually are, right? You better think about what horse you put them on. You better think about having them do some laps in the arena or the corral before you turn them out, right? So think about that. We'll talk about a case on that in a minute. It's an exception if the injury was caused by a dangerous latent condition of the land owner controlled by the defendant for which warning signs were not provided. So, right, if you're sending somebody out on a trail ride and you know there's big hidden holes or something, you got to warn them. It's an exception if you acted with willful or wanton disregard for their safety, if you intentionally caused an injury, and then there's a stock show exception, and we won't get into there. Okay, I want to talk to you about two cases that have come up fairly recently that I think are really important. And I think what these cases are going to illustrate to you is that this is a defense. It's not a silver bullet because it doesn't always apply. Okay, so the first case is out of the Waco Court of Appeals. It's called James versus Young. In that case, the Young family invited the James family over to their ranch for the day. The men had worked cattle all day, and at the end of the afternoon, kind of everybody was outside, and there were all these horses tied up at the barn. And the 6-year-old from the visiting family wanted to ride a horse. And so they pulled 2 horses off the fence, put the kid on one, somebody else on the other, told him ride down to the end of the road, turn around and come back. So they rode to the end of the road, they turn around. What happens? Barn sour horse, right? He sees all of his friends. He takes off running, kid gets bucked off and gets injured. So the James family files a lawsuit for negligence against the horse owner. The horse owner raises a defense, right? Farm Animal Liability Act. This is classic inherent risk injury. So he asked the court to dismiss the case. The parents of the child say that there's an exception applies. It's that second one I told you made me nervous. So they said that the horse owner provided the horse to the child and did not make a reasonable and prudent effort to determine the ability of the child to safely engage in the activity and to safely manage the animal. All right? If the exception applies, the case goes forward to a jury. If the exception does not apply, the Farm Animal Liability Act defense means the case gets dismissed. What do you think happened? Okay, the answer in this case is that both the trial court and the appellate court sided with the horse owner and they dismissed the case. And I think that there was one big fact here that played into that. Who was standing there when that kid crawled on the horse? His parents, right? If mama lets you crawl on the horse and doesn't say anything, that's a bad fact for her lawyer. It also came out during depositions. This kid grew up on a ranch. He had his own horse. He'd ridden, plenty of times. So factually, that was good for the plaintiff. But even with those facts, it was a 2-to-1 opinion at the Court of Appeals. And there was one judge that would have let this case go to a jury. So again, just keep in mind, it's not bulletproof, right? But it is a potentially useful defense. Okay, the second case is real recent. It came out in the last month or so. It's called Walk versus Zuniga. And in that case, we had a ranch hand who was killed while he was trying to move some cattle. So the owner of the ranch had told this guy, hey, we need you to move this bull. And then there was a cow-calf pair. We need you to move them from one pasture to the other. When the owner got home, he found the ranch hand dead in the corral. The autopsy showed blunt force trauma, likely from one of the animals. The employer did not have workers' compensation insurance, which means that the family of the deceased ranch hand was able to file a lawsuit in court. So they filed a negligence lawsuit against the employer. I think it was negligent training, maybe negligent supervision, negligent hiring, something like that, against the employer. And then, as you would expect, right, the employer raises the Farm Animal Liability Act as a defense. It's an inherent risk that when you're moving cattle, something could happen and you could be injured, right? So he raises the Farm Animal Liability Act as a defense. The trial court dismisses the case, right? The injured party appeals, all right, so the man's family appeals, and the Court of Appeals reverses. And they issued an opinion that said, the Farm Animal Liability Act doesn't apply. My slide here is wrong. I'm sorry about that. What the Court of Appeals opinion said was, the Farm Animal Liability Act does not apply if the injured party is an employee. So ignore that slide. The court said it does not apply if it's an employee that's an injured party. It might apply to an independent contractor, but not an employee. And this guy worked for them for years. He lived on the property. He only worked for them, etc. So the court said he's an employee. The statute isn't a defense if you have an employee that's injured. So the landowner appealed the case to the Texas Supreme Court. They affirmed, in other words, they sided with the injured party, but on different grounds. They didn't draw any sort of distinction between employee or independent contractor. What they said is that the act does not apply if the injured party is a rancher or a ranch hand. And the majority opinion kind of looked at the statute and came up with this theory that it was really intended for things like trail rides and rodeos and horse shows. It wasn't intended for activities that occur on a working ranch. I don't say this very often. I'm probably gonna get myself fired. I think that's flat wrong. There's nothing in the statute that says that. There's a dissenting opinion that did a really good job, I thought, of saying, look, the statute doesn't say that. It doesn't make that limitation. It doesn't make sense to not let this apply to working ranches. It also said that, it says, all persons are not liable. It doesn't say all persons except for ranchers are not liable. So I thought there was a good dissent, but the law right now, at least in Texas, is the act does not apply if the injured party is a rancher or a ranch hand. Potentially that could be fixed by the legislature. We'll see if this is something that may be brought up in the next session. Sometimes that happens where the court will interpret a statute. The legislature doesn't like the interpretation and they'll go change the language to kind of fix it where that's, court doesn't interpret it that way anymore. We'll see if that happens. But certainly in case, I think that's concerning if you're operating a working ranch. Okay. That's the end of my spiel. So I'm going to give you guys a couple of resources here, and then I would love to take any questions that you have. We've still got about 20 minutes for your questions. So type those in the chat box, and in a minute, I'll open it up where you can unmute yourself and we'll take those. The first resource that I want to mention to you is a handbook that I've written. It's called Owning Your Piece of Texas, Key Laws That Texas Landowners Need to Know. What it is, it's basically just a handbook on agricultural law. There's about 13 or 14 chapters that gives you a kind of a layperson's overview of different issues. So there's, oil and gas, water law, fence law, landowner liability, solar leases, property taxes, all of that's in here. If you want to get a free copy, you can download a PDF from my website. I'm going to show you that on the next slide. So if you want a free PDF, we've got that for you. If you want a hard copy, we have to charge for those just because of printing and shipping. If you want one of those, you can contact my assistant. Her name is Lucretia. That's her phone number there. It's 806-677-5600. And she can help you get a copy ordered. Okay, the next resource I want to show you is my blog. It's called the Texas Agriculture Law Blog. You can Google that name, or you can go to this website here, agrilife.org/TexasAgLaw. What this is, it's just a website where I post ag law info. So once a week, I do a post on everything from new cases to checklists to reports that come out, overview of different laws. You can find it there. When you go, there's a box that's going to pop up and ask you to put your email address in to subscribe. If you do that, my post will just come to you as an email when I do one. So you don't have to come and like check every week. Check that out if you want to. If you want a copy of that Owning Your Piece of Texas book, or you want to see any of the other handbooks or fact sheets I've done, just click right there on that tab that says Published Materials. If you click there, you can get free PDFs of all of my publications. Okay, the last resource I'll mention is a podcast I have. It's called Ag Law in the Field. If you are a podcast listener, we're on all your apps, the podcast app, iTunes, Stitcher, Google Play, anywhere you listen to podcasts. If you've never heard of any of that, don't worry. It's just a website. So I have a website. If you go to aglaw.libsyn.com, if you will go to that website, what you're going to find when you get there is about 90 episodes where I interview an ag lawyer about a different topic every time. You can listen to them for free on your computer. You just scroll down and pick the topic you want, click the play button, and what you're going to hear is an audio-only interview with an ag lawyer. Again, there's 90 of them, so we've done everything from estate planning to hot topics in the beef industry. We've done a lot on eminent domain. We've done some oil and gas, water law, you name it, it's there. It's free to listen to if you're interested in that. So my last slide here, and I will tell you, Philip is going to email the slide, or it may be Lindsay, but somebody's going to email the slides to all the participants today. So you'll have a copy of these. This is like basically my business card. It's got my email, my phone number. If you're on social media, give me a follow at Twitter or on Facebook. If you guys have questions after today, if you need additional information, I'm sure more than happy to help if you'll contact me. All right, so with that, I'm going to look at the chat box and see if we've got any questions there. Please continue to type those questions in, and in just a second, I'll let you unmute if you want to ask them aloud. Okay, so a question is, if a visitor on my property is injured by a hunter on my neighbor's property, do I have any responsibility? Man, likely not. Hard for me to imagine a scenario where something on your property or something you did could be blamed for a neighbor on your hunter injuring somebody. So no, I don't think there's much liability concern there. I will say though, and this is why liability insurance is so important, just because you wouldn't be held liable doesn't mean you might not get sued, right? So there could be a situation where that happens. They sue everybody, right? They sue the neighbor, they sue the hunter, they sue you, they just sue us all. And that's why that liability insurance is so important, right? So they can provide the defense to get you dismissed out of the case. But at the end of the day, no, I do not think you'd be liable for that. Catherine, if I hire cowboys once a year, are those considered independent contractors? Yeah, they likely are. There's a real complex test to figure out if you've got an employee or an independent contractor. But if you're bringing somebody in once a year, I'll almost guarantee you they're going to be considered independent contractors. Again, keep in mind, though, that now under the Farm Animal Liability Act, it doesn't matter if they're independent contractors or not, because they're cowboying and they're on a ranch kind of day working type thing. The statute doesn't apply because they're an injured ranch hand, which is stupid. What is the requirement for someone say there is a contractor? Okay, so if you have an independent contractor on your property, generally you're not liable for injuries caused by the independent contractor. As far as injuries to the independent contractor, it probably depends on what they're doing. If they got injured by their activity that you hired them to do, you're probably not liable if it's a true independent contractor. Right? And again, that test is tricky. There's a bunch of different factors to distinguish between an employee and an independent contractor. Okay. Now, if the independent contractor was injured by some condition on the land, potentially you could be liable there. They probably would be considered an invitee, and we could go back to that standard. But again, also why you've got that liability insurance there. Okay, if there's any other questions, you guys type them in the chat box. Okay, if the Cowboys get hurt, even though they are contractors, I am still liable. So it depends, right? We got to look at our defense folder. If I've got Cowboys out there and they get hurt, we don't think the Farm Animal Liability Act applies because of that walk decision. However, do any of the other things apply, right? Did you act reasonably under the circumstances? Did you warn them of dangerous conditions if that's how they got injured, right? Those could be potential defenses to keep you from being liable. So it kind of depends on the facts. Could you be liable for if a cowboy gets injured? Yes. Would you always be liable? No. It's going to become pretty factual when you're looking at that scenario. But because of that Supreme Court case, what I can tell you is the Farm Animal Liability Act is likely not going to be an available defense. Doesn't mean all the other things wouldn't be. Okay? Susan, would we be liable for an injury to someone who bales hay for us on the barter system? Potentially, right? So again, it's going to depend on the facts and how they were injured. So the question there likely is going to be, if they come on your property, they're probably an invitee, right? So did you warn them of any dangerous conditions you knew or should have known of that they couldn't see? If you did, you're probably not going to be liable, right? If you fail to meet that duty, that's when you could be liable. All right, so that's kind of how that would work in that type of analysis. Okay, any other questions? And if anybody wants to unmute yourself and ask one instead of typing, that's fine. Okay, here's a couple more. Catherine says, I have liability insurance, so if the Cowboys are hurt, would I let insurance? Yeah, so if you've got liability insurance, I would confirm that that would apply to independent contractors coming to work for the day. And yeah, if they were injured, I would call my insurance company. They would provide a defense to me, and that would be probably the best protection you could have in that scenario. Okay, Bob, I have about 25 beehives. I don't know much about those. I have about 25 beehives for the production of honey and wax. How do I protect against liability of visitors being stung or prevent neighbors if they're stung? Most likely not deadly, but possible. Yeah, Bob, I gotta tell you, I don't know a ton about beehives. What I would say on that is, I think that I would treat that just like anything else, on the property. I would absolutely have warnings up for anyone, right? Whether it's a trespasser, a licensee, an invitee, I would have some sort of probably warning signs that say we've got, honeybees and beehives. I think that's really important. I think, if somebody was injured, I think it would be that analysis of what's their category? Are they a trespasser, an invitee, a licensee? Again, why I think it's so important to provide those warnings, right? Because if you warn them about it, then you've got a defense there. I'd also make real sure my liability insurance would apply to cover any injuries to someone from the bees. Oh yeah, Philip makes a great point. Make sure you check your email. He's gonna send out a quick evaluation about the program today. That's really helpful to him. And he's gotta have that for kind of his bosses when he evaluates programs. So if you'll please fill that out, we'd appreciate it. We'll also make sure you get an email with the slides from today as well. Any other questions? We've still got a few minutes. Okay, I'm gonna give it a couple more minutes. If anybody's got questions after today, again, you can always call me or email me. I'll sure do my best to help answer those for you. I'm gonna give it just a couple more minutes in case somebody else is gonna come up with another question.
Tiffany, I'm going to send an email out now to folks, and they'll find it. It'll come to them. It'll just be in blind copy. So in other words, it should just come. The survey just come to them, and they won't see everyone else's email address. Some folks are, you know, don't want their email address sent to everyone, and I totally understand that. So they should see it, just the survey just come to them individually. Uh-oh, was I muted or did I put that right?
No, we got it.
Okay.
Any other questions?
We're using, Tiffany, let me tell everyone else while they're still online too, I'm using a new survey system. So if something malfunctions, I'll send it to you again. I'm sending the survey to a few folks that I know so I can kind of test it and make sure it's working right. And I've tested it in the past, but as we all know what technology does, if it's going to fool you, it's going to fool you when you really, really need to use it. So hopefully this works well. And again, we can hang on a few more minutes, Tiffany, obviously, but I
Sure.
personally thank you again for spending your time with us today. And wow.
Oh, yeah,
Yeah.
there's a question here.
Okay.
Susan says she lost her internet for a point here. Is this going to be available afterwards? I know we recorded it.
Yes.
So Susan, if you'll contact me or Philip, we will figure out how to get you the recording. That's no problem.
We certainly will. We'll do that, Susan. We'll make sure we can get the recording to you. And Tiffany, I assume that the slide presentation,
Yes.
we can get. Yeah. Okay. Gotcha.
Yep.
Okay.
Yep. No problem.
All right. Well, while I've got folks here, I'm going to hit the send button and hopefully that will go to them. And hopefully they'll get that. And thanks again for doing the survey, folks. That is really important because it really helps us identify what's good for you to know, what kind of information you need to know in order to run your business or keep your property safe. And so let us know. There's some questions in there. Certainly open up and you know, if it's just something you need to know about, let us know. Or we can put something together. We have got specialists, just like Ms. Lashmet, that is all over the state that you name it, we've got it. So let us know what we can do to help you.
All right. Sounds good. Well, Philip, I don't see any other questions. Like I said,
Okay.
feel free to follow up afterwards. I'm sure glad to help however I can.
Can you take a verbal question?
Sure.
I can't figure out how to send this.
No
The
problem. We hear
Question
you.
is this. On our property, we have a 100-foot right-of-way from electric power line company. It was made in 1939, and my family was paid $10 for it.
Yeah.
We have contractors that come through, and I have a constant problem with them leaving my gates open and my electric fence laying on the ground.
Yeah.
Cattle got out, and there's a 32-foot opening at the highway, very, very busy highway. Who's the liability?
So there's a couple.
We actually own the land, but they have that forever
Easement.
right of way through our property.
Sure. So a couple of issues here. The first question is going to be, are you in an area that's open range or closed range? And that matters because that discusses whether you have a duty to keep the animals off the road.
What do you mean by that?
Is it like a state highway?
Yes.
It's not a farm to market road.
No, ma'am, it's a state highway.
Okay. So I can help you there. For a state highway in Texas, it's closed range, right? Which means that the animal owner has an obligation to keep them off the highway. If they were to get out, there's the potential for liability. And in all likelihood, what would happen is they would likely sue you and they might sue the electric company as well. What
Yes.
you would want to have is some documentation where you have told the electric company this is a problem, right? You've told them you need to make sure you close this gate. This is going to be an issue. Somebody could get injured. You know, I would paper trail them to death on that, to where if something ever did happen, that's exhibit A in court for you to point the finger at the electric company.
Yes.
So-
The problem is you can't be, I mean, your busy daily activities, you can't be watching that, and they don't give you any kind of prior notice that they're coming. They just come through, and they have to go a long ways to get down to the next property and then the next property. So
Sure.
it's just a constant vigilance to watch those gates.
Right. No, I understand. It's a major problem. I mean, and look, in a perfect world, there would be something in the easement that required it and some sort of damage clause in there. An easement from 1939 is not going to have that.
No.
Yeah, it just doesn't have it. So, like I say, I really would do the best I could to paper the crap out of that. And don't just tell the guys that are there, right? Because clearly they don't care. You need to try to get that. You need to try to get those letters to like supervisors, CEOs, or legal, right? If you can get that in the hands of the general counsel, somebody's going to get their butt chewed.
Yeah.
So if you can figure out how to do that, that may be beneficial as well.
Well, the situation was last year, I had a guy in the truck with the cattle standing right at the gate, and he refused to get out of that gate and close that gate. He wanted to get out of that gate and fist fight with me. He literally wanted to fist fight with me, but he would not get out of that truck to close that gate to keep those cattle from coming through.
That's insane. And like I said, from a liability perspective, again, I would paper trail it. I would make sure I had good liability insurance that covered animals out on the road, because you're going to get out of that lawsuit. From a practical perspective, though, right? I mean, look, I don't just want a defense if something happens. I want to keep something from happening.
Yes. Thank you so much. I appreciate it.
I hope that's helpful.
Yes, ma'am. Thank you.
Anyone else?
Just curious, did anyone check the email? Did they receive that survey okay? I think there's another one there, Tiffany, real quick.
Okay. Oh, Tracy says you could put up game cameras to catch the license plate of the company employees traveling on the right of way. That works well if you don't know who's on there. Absolutely. The other thing that can do, right, is it can show, you can have evidence of them leaving the gate open, right? To where if something does happen again, you can show there's a history of this. That's a really good idea, Tracy. Okay, and Kimberly says they have received the survey, so that worked out well.
Oh, great. Thank you, Kimberly.
Okay, Philip, it looks like that may be it.
I guess that's it. That's it. We're almost on top of 10:30. So if anyone has any more questions, or you think of something after the program, by all means. Thank you, Marion, for letting me know about the survey, and Vernon. You can certainly call or email Ms. Lashmet, and she'd be more than happy to help you with that as well. And she's this is the second time I've heard this portion of liability, and man, has it been helpful for me. I've got dove hunters on the place right now, and I tell you what, before this program, when I heard this portion at the beef cattle short course that she did on liability, boy, it made me sit up and go, whoa, wait a minute. I need to double check some things just to make sure. And we've had dove hunters on the place for years and years and years and years. And thank goodness, thank the good Lord, nothing has ever happened. But it is always good to know, no matter whether you're doing something with agritourism or hunters or whatever it might be, someone just walking onto your property to have a barbecue in your backyard, you got to be careful nowadays. Well, anyway, with all that being said, Tiffany, thanks again. Look forward to other programs we may be able to do in the future. And folks, let us know in that survey what else would be helpful for you. We will be sure to try to address those things that will help you in your everyday life. Well, without further ado, Tiffany, I guess that's it.
Okay, sounds good.
We'll leave it at that. All right. Stay warm up there.
Yeah, I'll try.
Take care.
Thank you.
Bye, everybody. Thanks again.